Hi, welcome to all of our students, fellows, and board members. This is the second of our second of our three Alabama 101 lunchtime meetings. And today we're lucky enough to have Othni Lathram, who is here. He's going to be talking to us about Alabama's constitution and our government structure. So just very briefly, he is the director of the Legislative Services Agency. And previous to that, he practiced as a lawyer in Birmingham. He's focusing on complex legislation. He received his BS in economics from Auburn and his JD from the University of Alabama, so a big roll tide to that. He is elected as a member of the American Law Institute. He's also a commissioner with the National Conference of Commissioners on Uniform State Laws, and he serves on the Alabama Supreme Court's Standing Committee on the Rules of Civil Procedure. He also is a member of the Executive Committee of the National Conference of State Legislatures and a member of the bar in Alabama and Texas, and he's also able to practice before federal and circuit courts around the country. So without any further ado, I'm going to hand it over to Othni, and he's going to take us through until about 1 o'clock. And if there's any time for questions, we'll take those as well. So thank you all for being here.
Fantastic. Thanks so much for that great introduction. I'm really excited to be with y'all. This is something I've been looking forward to for a while. I think we first started doing this last spring or setting this up, and we've moved it a couple of times. So I hate that we're virtual, but I'm thrilled to be with you. So a couple of things up front. Number one, you know, I'm used to kind of doing this more in person, so bear with me. I'm not quite as experienced with Zoom as probably each of you are, but I do want to try to make it as interactive as possible. So I'll try to save some time for questions at the end, but if you've got something while we're on it, I'll try to pay attention, and if you wave or if you write it in the chat box, I'll do my best to cover it. Secondly, covering the Alabama Constitution of 1901 in an hour is a pretty daunting task. So we're going to breeze through some of this stuff pretty quickly, and so again, if I'm moving too fast on something that you think is really interesting, let me know. And I'll slow down and dwell on that part or attempt to a little bit more. So I think I just shared my screen with you. And of course, what that means is I lost the chat box somehow. So I'm going to try to see if I can bring that back real quick. Let's see. There we go. All right. So now I've got the chat box back. So I'll make good on my promise to try and pay attention to that if you've got any questions. So first off, you know, and if this was in person, you know, we'd holler back and forth a little bit more, and I won't quite make you put you through that exercise, but a number of you probably have some pre-consisting notions about the Alabama Constitution. If you do, just throw the first word or two that comes to mind up in the chat box, and in a couple of slides, I'm going to come to those, and we'll talk about those things. So, you know, just your immediate reaction when somebody says Alabama Constitution, I'd love for a few of you to put some stuff up there, and we'll talk about those. And first, what we're going to kind of talk about before we get to that one is that I think it's important to kind of lay some groundwork and talk about what is a constitution. And so, you know, I really like having this conversation with grade schoolers because you get some great answers. I mean, it's really pretty impressive, you know, kind of instinctually what folks at a very early age, kids at a very early age, think about a constitution. I won't put you all through that same thing, especially given the technology restraints. But at its essence, and here's the legal definition. This is what Black's Law Dictionary, which is kind of the go-to for us legal nerds on defining words is. It's the organic and fundamental law of a nation or state. establishing the character and conception of its government, and laying the basic principles to which its internal life is conformed. That's a pretty fancy legal answer. So I like to shorthand that to essentially say a constitution is a contract between a government and her people, setting forth the terms by which they agree to be governed. What does that mean? What it means is we choose, or our ancestors chose or were forced to be part of the United States, right? And at some point in time, we formed a government. And that government, in order for us to live as kind of a cohesive society, needed to establish some contract between how it was going to operate and the people that live here, right? And so what do I mean by that? What I mean by that is, there's no kind of natural inherent law that governs how fast we should drive. I mean, there's some notions about, what my safety might dictate, what my concern for others might dictate, my risk reward about my own personal well-being. But there's no kind of natural overarching law that governs that. Well, when you're part of a society, you choose, kind of for the global good, I'm going to give up my right to go 100 miles an hour in exchange for government kind of providing roads, keeping them relatively safe, paving them as best they can, giving me means to get from Alabama to California, which I did a few weeks ago on a cross-country drive. And so that's kind of, that's overly simplistic, but that's kind of what we're talking about, is that we agree as people to give up certain rights in exchange for government taking on certain obligations. And so that's what a constitution is. I'm going to ruin the plot and go straight to the end. The Alabama Constitution of 1901 is maybe the worst example of that has ever existed. It's just not what it was intended for. There's some smatterings of that. There's some stuff in there that you can look to and point it out, but it wasn't set up that way. The Constitution of Alabama of 1901 was really set up as what I like to call a super code. So it kind of micromanaged a whole lot of things that aren't part of that basic contract. It put in a whole lot of speed bumps about how government has to operate, because, to be honest, and Alabamians are still a little bit this way 120 years later, it was a pretty distrustful people of government. They didn't really want government to have a whole lot of inherent power. They didn't want the people governing them to make choices, for how their life would be led in a way that would be, that they might disagree with. And so the Constitution of Alabama is a terrible example of that. Contrast perhaps the US Constitution, which is probably one of the better, if not the best example of meeting that definition in the history of mankind. It certainly had some flaws as well, probably more in the implementation of the Constitution than in the words itself, but a very succinct document. This is probably going to fail because of technology too, but if you can see my very well annotated Constitution of Alabama here, this portion of this is actually the Constitution of the United States. This is about a third of the Constitution of Alabama, by contrast. The US Constitution and its 27 amendments, which kind of very succinctly lay out, this contract, as opposed to kind of this super code of law in the Alabama Constitution. So now let's talk a little bit about where it came from, right? So the 1901 Constitution is actually our 6th Constitution as a state. And I know y'all have already gotten a little bit of an overview of the history of Alabama, far better than I could give you. My perspective is kind of very limited to government operation and the like, but the 1901 Constitution is the 6th Constitution. Why is it important to think about that? Well, first off, unlike the US Constitution, this wasn't kind of the noble envisioning of what a new land looks like, right? It's a much more kind of practical approach. If you look back, Alabama became a state in 1819, just celebrated our bicentennial as a state last year. And so that statehood constitution, or first principles constitution, was 80 years earlier than the 1901 Constitution. Then you kind of had, that very painful part of the U.S. history, leading up to the Civil War, post-Civil War, and in a period of less than a decade, we had three constitutions kind of right on top of each other. The 1861, where we seceded from the Union, kind of the 1865, which, is kind of the equivalent. I mean, it was very rushly done. It's, last year as part of our bicentennial, there was a great display at Archives and History of our 6 constitutions. And that 1861 one in particular looked like it was written on the equivalent of a legal pad in 1861. I mean, done very, very hastily, a very quick effort to get readmitted to the Union. Then you had the 1868 Reconstruction Constitution, which was much more of kind of the federal government coming in and mandating, here's the list of things you have to do. As soon as the federal government got back out of Alabama, we almost immediately passed the 1875 Constitution, which was, it's kind of known as the results of the war to be reversed, kind of Alabama going back to its bad past a little bit as soon as, mom and dad left the room and are no longer kind of keeping a direct thumb on things. And then the 1901 Constitution, which was even kind of more that way. Interestingly enough, if you look back at kind of compare how things work today to how things worked then, only our 1875 and 1901 constitutions were ratified by the people of Alabama. The other 4 were kind of done by this governing class, and when adopted, kind of magically became law, even though it was only a very small set of subset of people who were involved in it. The 1819 one was approved by Congress. That's how it was deemed ratified. And that wasn't uncommon. In fact, the first constitution in the United States to be ratified by kind of the electorate, or the population as a whole, was the 1857 Minnesota State Constitution. And that kind of changed direction, or started a trend of people having a direct voice. And so it wasn't until that 1875 and 1901 period where these constitutions were actually ratified by the voters. And you can look back, and it's very well historically documented, and we could spend just days talking about kind of the voter suppression of how these particular documents got ratified, how who was allowed to vote were picked and chosen, those sorts of things. A very painful period kind of in the arc of history for Alabama and other southern states in particular. So now I'm going to scroll back up in here. So longest ever. So those are that's some of what I expected to hear. You also hear a lot that it's racist and it's sexist. Both of those things are true too. The truth is, and it gets back to that kind of same notion of ratification by the people, the entire concept of the 1901 Constitution was to consolidate the power of governance into the hands of landowners, and significant landowners at that. And if you looked at who was significant landowners, it was white men. And so, which comes first, the chicken or the egg, same sort of thing. You can debate back and forth, but there's no doubt that power was very centralized amongst the kind of upper crust of white males in the state who were the landowners. It is very long. We're going to talk about how many times it's been amended in just a minute, and I showed you all the book. It is long. I think it's the longest ever. I've never personally verified that, so I don't know that I'd say that under oath, but I certainly think that if it's not the longest, it's right up there, and I have no reason to debate that it is. So let's talk a little bit, and this is why our Constitution is so long, is because of how many times it's been amended. And kind of, one of the things that, and this builds on the fact that it was our 6th Constitution a little bit. One of the things I tell people is I think no one would be more surprised that we still have the 1901 Constitution 120 years later than the people who wrote it. I mean, these were people who had written 5 constitutions in their lifetime, right? In one generation of time, they had rewritten the state constitution 5 times. In fact, there were things in the Constitution that by their very terms expired in less than a decade. And so they were speaking to kind of the immediate crisis of the day. You know, we're going to talk a little bit about how we don't have home rule, how we limited, you know, what local government can do. And the reason for that was that we were dealing with, you know, some pretty significant, you know, bankruptcies, or the equivalent of the day of what bankruptcies were of local governments. We had local governments who had gone into huge debt, you know, both leading into the Civil War and then post-Civil War rebuilding, and weren't able to pay their debts. So, you know, we wanted to rein in how much authority they had to issue debt. You know, we were addressing very specific, timely issues in a way that caused us to repeatedly, you know, kind of rewrite that Constitution. So I don't think they expected, you know, if they got their crystal ball out and looked to 2020, I think they'd be very surprised that we're still using that document. So it's been amended 948 times. So my Kiwanis Club speech for this current cycle is #RaceTo1000, trying to sound a little cooler for my teenage kids. And I think we'll make it, right? I think, you know, one way or the other, we're likely to make it to 1,000 amendments by 2022, or the close of the current state quadrennium that we're in. And so let's talk a little bit about kind of why we have so many amendments. It's one thing to kind of just, you know, be interesting that we have them, but let's talk about why. So one of the examples I love to talk about is Section 93 of the original Constitution. And this kind of fits everything I was just talking about as far as motivation. The state shall not engage in works of internal improvement. Let's just stop there. What does that mean? That meant that under our Constitution, the state couldn't build roads, couldn't build courthouses, couldn't build schools, couldn't build ports. That's crazy. I mean, those are kind of main functions of government, is to build these things for the common good of what needs to be done. And so why was that? Why was that written into the Constitution? It was written into the Constitution so that if government wanted to do those things, if government wanted to spend a significant amount of money, they had to come back to the voters and ask permission. And so the First Amendment to the Constitution was that they can, in fact, do that, right? Provided the state may, under appropriate laws, cause the proceeds to be applied to construction, repair, and maintenance of public roads, right? Just a couple of years into the Constitution, they said, hey, guess what? We were wrong. We do need roads. We don't need to have a vote of the people every time we need to build or repair a road. So let's amend the Constitution and give government that right. So that was the First Amendment. So if you look through 2020, we've amended the Constitution 223 times on statewide amendments and 725 times on local amendments. This local amendment bar is particularly interesting. We're one of only a handful of states that so easily allow for a local constitutional amendment. So let's think back a minute to what we were talking about the Constitution is. The Constitution is a contract between people and its government about how they'll be governed. We think 725 times over the last 120 years, that should be different in one county or one city than in the rest of the state. Just let that sink in for a minute. I mean, that's a pretty amazing concept. We have exceptions to our core organic governing document that only apply to one county or one city 725 times. That's nuts. I mean, it means you go county by county and don't even really know what the law is unless you're a constitutional scholar who knows what's been going on over the last 120 years with these local constitutional amendments. So I'm going to breeze through these next slides pretty quickly, but they kind of give you a quick summary of kind of when we've done this. And you'll look, one of our more active periods has been this last decade. So we'll talk a little bit about some of the stuff that was happening in the 50s and 60s in a few minutes that caused these spikes. But pretty amazing to see, and you'll see kind of crescendo here coming on the local constitutional amendments as well, just becoming more and more frequent. So again, these just kind of tell you, the other thing I hear a lot about is, oh, pass a constitutional amendment, let the people vote. They vote them all down anyway. That's really not true. So if you look at this chart, kind of covering the last 30 years back to 1992, each green box is an election cycle where we had a north of 2/3 ratification rate of the amendments that were proposed. So on average, we're ratifying far more constitutional amendments than we're turning down, at least in the last 30 years. And that's a pretty interesting concept, given kind of how Alabamians react in general to government. You would think it would be, far fewer than that on average getting ratified. All right, I messed up there we go. All right, so now let's talk about what I think I'm really supposed to be talking about, which is the, kind of the structure of the Constitution and what it means for the structure of the government in Alabama. And I'm gonna do this by kind of going through, there's 18 articles in our Constitution that are kind of, the chapters, so to speak, of how the provisions and amendments of the Constitution are organized. And so we're going to breeze through these. Some of them we're going to cover really, really quickly. Some of them, like the legislature, since that's what I do day in and day out, are far more interesting. So we'll spend a little more time on them. And again, feel free to throw up in the chat box any questions or comments as we go. So Article 1, Declaration of Rights. This is kind of, if you just looked at our state Article 1, you'd say, oh, Alabama's got an interesting constitution, right? I mean, our Article 1 is where most other states largely stop, or where the federal government stops. It kind of lays out, if you think about maybe the Bill of Rights, this is where this stuff kind of is, right? Section 1. I'm not so sure we were living this in 1901, but a very, nice, succinct, aspirational, all men are equally free and independent, endowed by their creator with certain unalienable rights, including life, liberty, and the pursuit of happiness. That sounds pretty familiar to us, right? I mean, I think that was pretty well plagiarized with a couple of tweaks from from a document we've all seen at the federal level, right? The second one's a little bit more interesting, right? I mean, this kind of, in that nutshell, gives you, the glimpse into what I was talking about, how surprised they might be that this Constitution was still in play 120 years later. That all political power is inherent to the people, and by people, insert landowners, right, and all that meant, but inherent to the people, and all free governments are founded on their authority and instituted for their benefit. So in other words, government only exists to serve the people, the landowners, right? And therefore they have inalienable and indefensible right to change their form of government however they deem expedient, right? This is kind of, a poke in the eye to the federal government too, right? This is kind of saying, hey, we're past, that Reconstruction period where we've got this checklist of things where the federal government's going to make us do them, and we're going to kind of lay out really early in this document that government exists for us and we control what it looks like. Then you kind of skim through the rest of Article 1, and again, it looks largely familiar to kind of what other constitutions, what the U.S. Bill of Rights looks like. Religious freedom, freedom of speech and press, no debtors' prisons, eminent domain property rights, right to bear arms, right? All that sort of stuff that's kind of ingrained in our mind as kind of the rights we preserve as citizens of the state and of the country. Article 2, we're going to just breeze right by. It's the boundaries of the state. Not much we can do about that. They're dictated, obviously, at the federal level. And then it provides a process by which, the counties are to be formed. And I think in 1901, we had the same 67 counties we have today. So we haven't really, this hasn't been an area of much upheaval. Article 3, distribution of powers. This is really pretty fascinating, right? And it's an area where the Alabama Constitution, kind of takes a branch of a turn from the feds again too, right? And by that I mean, all of us know this notion, from Schoolhouse Rocks about three branches of government, three co-equal branches of government. Guess what? The federal Constitution never actually says that. The federal Constitution sets up an executive branch, and it sets up a legislative branch, and it sets up a judicial branch. The Constitution never says they're co-equal, never says that they're the exclusive purveyor of those powers. That was all done. That heavy lifting was done by a U.S. Supreme Court case in the early 1800s, Marbury v. Madison. Unlike that kind of implied separation of powers, the Alabama Constitution has an express distribution of powers provision. Sets up an executive branch, a legislative branch, and a judicial branch. Says that they shall each exercise that power given to them under the Constitution, and they shouldn't exercise each other's powers. Interestingly, this is kind of where you start seeing, though, they're not really co-equal. So again, these people were kind of reserving power as much as possible to themselves. So who does that mean you give it to? You give it to a legislative branch. So if you're going to have disproportionate power, you kind of disproportionately give power to the legislative branch for a couple of reasons. One, the governor works full time, the legislature doesn't. So there's a lot more time for the governor to get into mischief than the legislature to get into mischief. Number two, it's one person acting versus 140 people acting, right? You've got much more influence, and kind of, it's easier to kill something when you got to get, a majority out of 140 than when it only takes one person to act. So some of the things we see where they start kind of shading the power to the legislature, simple majority veto. Under federal law and most other states, you need a super majority to override a governor's veto. Here, it's a simple 50%. When we get a little later, we're going to talk about another quirk of our Constitution called the Budget Isolation Resolution. And just suffice it to say, it usually takes much more than a simple majority to pass a bill. So it takes fewer votes to override a veto than to pass a bill in the first instance under most circumstances. And then equally on the judicial side, they kind of shave power back to the legislature on a couple of fronts. One, they gave the legislature co-rulemaking authority. So the legislature or the court can set its rules. And secondly, no state court can enter an order that would cause state dollars to be spent differently than how the legislature appropriated them, unless the legislature has an affirmative vote to uphold that order. That's a pretty wild concept, especially for people who are used to practicing law in federal court, where judges all the time order the government to do this or order this to happen. Under state law, the courts really don't have that authority if it causes money to be spent differently than how they're appropriated. I'm going to note just for a second up here on a few of these slides, you're going to see a ratification date of fairly recent. So hopefully we'll have enough time to talk a little bit about the efforts at reforming the Constitution over the years. But the only effort that's ever made a whole lot of progress, or at least some progress, was a constitutional commission in the last decade that worked on rewriting a few of the articles, and those few articles were ratified in recent history. So distribution of powers didn't make a whole lot of substantive changes. Believe it or not, originally the executive, judicial, and legislative were departments, not branches. So some stuff to make the terminology a little bit better, some taking out outdated language, making it more gender and race neutral. Those sorts of things have been done in a handful of articles. This is one of them that was ratified fairly recently. So the legislative article, again, this is kind of where a lot of the work gets done under our Constitution. And it's kind of as important for what it doesn't include as what it does include. So we talked a little while ago about home rule and kind of our general lack of home rule. What I mean by that is that most counties, it's different for cities, and if we had more time, we'd go into more detail about why that is. But most counties don't have the authority to set their own taxes or regulate land use within their county without coming to the legislature and getting a local law passed. And so that whole process is kind of laid out in the legislative article, what that looks like. It sets the parameters for kind of when and how we operate. So just, for way of background, the legislature meets annually today. And it comes into session each year for 105 calendar days, and they can meet 30 legislative days in that 105 calendar day window. And so it's a very limited duration of when the legislature is in session. If they need to meet outside of that window, it has to be done by a special session, which can only be called by the governor to cover kind of an extraordinary, and that's pretty loose how that's defined, but extraordinary circumstances to bring them in. Each kind of legislative cycle is broken into 4-year categories. We call them quadrenniums. And the whole legislature, all 140 members, are elected simultaneously each 4 years. And so House members and senators have the same term of office. So let's talk a little bit, and we're going to move through these slides pretty quickly, but what has to, what has to happen to pass a law, or kind of what the Constitution lays out for how laws are passed. Remember that these were, a lot of these rules date back to 1901. So they were kind of written, to protect the status quo. They were written to make it difficult to pass laws, and they were written to kind of keep legislators honest, so to speak, right? And there weren't copy machines, there weren't, there wasn't kind of advanced technology. And so they wanted to have some extra hoops in place, for that legislative process to kind of slow things down, give everybody a chance to know what they're really voting on, and have a chance to learn it. So Section 45, single subject, most states have this. It's unlike federal law where you might get a bill that's 2,000 or 3,000 pages long. And under state law, you're supposed to have, bills supposed to cover a single subject, cover one thing, not kind of an omnibus bill or territory. Second, each house, gets to set its own rules for proceedings. So at the start of each quadrennium, each house of the legislature passes a set of rules, sets up its committees, elects its leadership. Those are only good and binding on that legislature, so that 4-year period. Section 56, and then we also have a equivalent legislative privilege statutory section. This is kind of the speech and debate clause. You hear a lot, and it's played up sometimes in TV shows. Oh, you can't arrest a legislator or a member of Congress during session. That's not exactly true. You can for felony, violation of their oath of office, breach of peace. You can write them a ticket, but you can't kind of detain them on their way to and from the legislature to block them from doing their business. And also anything they say while engaged in their business is protected. So they have pretty, you can't get them for libel or slander or, that sort of thing for vigorously debating something during the course of passage of a bill. A bill can't become law unless it's referred to a standing committee. It's got to be reflected in the journal. Again, these are kind of speed bumps, so to speak, in the legislative process, so that people have an opportunity to know what's going on. Have to read it on 3 different days, the 3 reading rule. If you want to raise taxes or revenue, that bill's got to start in the House. Again, kind of a mechanism so people would know exactly where to go to look if somebody was, doing that dreaded raising taxes activity. So here's the BIR, the Budget Isolation Resolution. This is an interesting concept. So really the legislature's only mandatory rule each year is that we have to pass a budget by which the state operates. And I'm not going to talk a lot about the budget because I know y'all are going to have a whole session on budgeting and state revenues next week. And so I'm not going to, tread on that turf, but I do want to kind of introduce a couple of concepts that I think you'll hear built upon next week that are constitutional in nature and important to know. So the first is that's the primary role of the legislature, pass a budget. So at some point in time, we amended the Constitution to say, hey, if the legislature wants to pass something other than the budget, and they haven't yet passed the budget, we want to remind them that they're not doing things right. And so they have to first pass a resolution by a supermajority, a 3/5 vote, to say, hey, we know we hadn't passed the budget yet. We're sorry. We're going to bring up this other bill anyway and debate it. So back to kind of my veto conversation. This is why I say most bills have to have more votes to pass than they do to override a veto, because if we haven't passed the budgets, you got to get a 3/5 vote. The second kind of constitutional concept I want to talk about budgeting that I think will be important next week to your conversation is earmarking. And earmarking is a phrase that means anytime revenue is directed someplace other than a state's general fund, those funds are earmarked. So if we pass a bill that says this money has to be spent on building roads, that's an earmarked dollar. That revenue is earmarked because the legislature can't control how to spend it. It has to be spent on building roads. Alabama earmarks more money than anybody else in the country. So depending upon what our different revenue streams are looking like, Alabama is usually in the mid 80s to low 90% of all revenue is earmarked. The next highest state is Michigan, which is under 55%. Now that's a little misleading, and we'll talk about why in a few minutes, but nonetheless, we earmark most everything. And then secondly, we're one of only a handful of states, it was 3 last time I looked, that have a separate general fund budget and education budget. And that's tied kind of directly to the earmarking conversation, because each of the dollars in that education budget is an earmarked dollar that has to be spent on education. And so, you know, earmarking kind of leads to that result. I'm going to breeze through these real quick because I want to respect our time, but sections, you know, 105, 106, 107 kind of deal with that whole local law concept and what's so important about how this works, you know, since we don't give the right to counties to act on their own behalf. And so a couple of things that are important. Number one, you know, that we can't pass local laws that override general laws. That's part of why we have so many local constitutional amendments, because a local constitutional amendment can override a local law, but a local law can't. Section 106 says that if you're going to introduce a local bill to do something that, again, most states would handle at the county commission level or local level, you have to advertise it in a newspaper for 4 weeks before the legislature can consider it. So, you know, nowadays, obviously, you know, probably the internet would be better than a newspaper, but the idea being you've got to make it clear what you're doing, give notice to the people so that they have an opportunity to track it. Unfunded mandates. Most people think of unfunded mandates from the federal to the state level. An unfunded mandate is when the federal, you know, government says, hey, states, you've got to do this, but they don't give you the money to do it. Well, local government thinks of the state in that way. You know, we're all the time telling local government, you have to do this service or provide this, and don't give them the money to do it. So section 111 is what says, if we're going to do that, it takes a super majority vote. We've got to know we're putting this burden on counties if we're not going to give them the money to carry it out. Article 5 is the executive branch. Establishes the key executive branch officers: governor, lieutenant governor, attorney general, secretary of state, treasurer, auditor, and commissioner of agriculture. Agriculture has always been Alabama's kind of #1 industry. And so we're one of a handful of states where that's true, where we actually have a statewide executive branch officer whose only job is to kind of look at how agriculture works in the state. Section 113, the supreme power of the state shall be vested in a chief magistrate style, the governor of the state of Alabama. And then Article 5 goes on to kind of mostly delineate the power and authority of the governor. Again, shaded a little bit towards the legislature, although I'll add a footnote to that. You know, if you've been paying attention, you know, the last 6 months or so, there's a raging debate at the national level and at most state levels about, and even at local, mayors, right? Mayor Maddox has been, you know, kind of taking some heat up in Tuscaloosa because you've got executives exercising kind of unilateral emergency powers during this pandemic and doing things that usually would require their legislative bodies to take actions on. So that's going to be something really interesting to watch in the next handful of years to kind of see how that bears out. Other than the governor, most of these other officers, the Constitution just says they exist. They get elected every 4 years. Legislature give them something to do, and then the legislature provides by general law kind of what their functions are. The judicial branch, Article 6. You know, we've actually got a more consolidated judiciary than most states. That's because in the 70s, then Chief Justice Howell Heflin Most of y'all are probably even now, too young to remember him as Senator Howell Heflin, which is what he was when I was a child. But in the 70s, he was the Chief Justice, and he reorganized the entire judicial branch of Alabama. And it was the first article to be rewritten and ratified. It should have one of those little ratified in 1973 tags up here, because most of Article 6 is not original to the Constitution. But it creates the court system. It kind of gives what inherent authority exists in the courts, and lays all that out. Article 7 is the impeachment article. The legislature has the authority to impeach executive branch officers and judicial branch officers that are elected statewide. This one was one of those that was redone by the commission in the mid-2000s and ratified in 2016, which was about a year before we were in the middle of impeaching then Governor Robert Bentley. If we had it to do over again, there's a whole lot of stuff that ought to be included in here that we didn't think about because we hadn't lived through an impeachment yet. But anyway, we might need to rewrite that one again. Article 8, suffrage in elections. If you look back at kind of the racist vestiges, a lot of the really problematic parts of our 19th Constitution were centered in Article 8. Article 8 was the second effort at kind of article by article revision. It was completely rewritten and revised in 1996. Prior to that time, you had things like literacy test reference. You had poll taxes. You had kind of all those vestiges of discrimination that existed in 1901 to keep people from voting. Were still in the Constitution. Most all of that was removed in the mid 90s. And basically, kind of it says who has the right to vote. This no person convicted of a felony involving moral turpitude is still something that gets, a lot of debate to this day. In part because it wasn't until a handful of years ago where kind of the legislature defined what was a crime of moral turpitude. So it still left a lot of authority in local election officials to decide who could vote and who hadn't if they had a criminal background. And so, this still isn't kind of a perfect provision, but we came a long way on this article in the mid 90s. Article 9, representation, sets the number of legislators. It really sets kind of a window of how, what the minimum and maximum are, requires redistricting every 10 years, and kind of sets up a provision for how we accept the federal census, or what we do if the federal census doesn't happen. And just as a footnote, next year is a redistricting year, right? We're living through the census right now. Lot of heady stuff, litigation going on about, whether the census will play out properly during this pandemic. Really interesting to watch at the national level what's happening about all that stuff. But at the end of the day, sometime in the next year, we'll have a new federal census, and we'll be required to redistrict, one person, one vote, kind of equalize the districts of both our congressional seats and then our state legislative seats, and a few other things. Article 10 is exemptions. This is kind of your protection, right? There's protections in most constitutions, ours included, that protect your homestead or a portion of your homestead and a portion of your income if you get into debt trouble. So like in a bankruptcy or the like. Those are in Article 10. Article 11 is taxation. I'm glad I'm not covering budgets and taxation, which will be covered next week. But again, just a couple of seeds to plant, and kind of how that conversation will unfold. So Amendment 211, which was, or Section 211.02, which was Amendment 61, passed in the 30s, was our first income tax. This is kind of the perfect example of Alabama constitutional law, because we tried to get an income tax in place. The people weren't real keen on being taxed, as you might expect. So how do you get there? Well, you tell them what the money's going to go for. So you earmark it. So since the 30s, every dollar that's raised under our state income tax, personal and federal, has to be used to pay for public school teacher salaries. So to this day, our largest revenue stream, almost $4 billion a year today, has to be spent on K through 12 teacher salaries. And that's the only way we could get an income tax implemented, was to convince the people that it couldn't be spent for anything else. Road and Bridge Fund, there was a little bit of debate about this last year, if you were in Alabama and paying attention, because we increased our gas tax for the first time in a generation. about 30 years, and that also, earmarked. And this one makes a little bit more sense. If you're gonna collect money on gasoline taxes, you ought to spend it on the infrastructure. And then 217, which gets a lot of heavy lifting if you're looking through kind of the vestiges of our state, is our ad valorem tax structure. So things like current use, right? That's where you get that agricultural land is taxed at such a fraction of say residential land, and that goes back again to kind of 1901 and kind of landowners self-protection and kind of how they set this up. Article 12, corporations, we rewrote this one and it was ratified in 2012. When we were digging through it, this is back to that super code concept, right? Had very granular regulations of how railroads have to operate, how telegraph companies have to operate. Hadn't been a telegraph company in nearly 100 years, but it was still in our Constitution until 2012. Article 13, banking, same sort of stuff. Had a provision in our Constitution saying a bank couldn't have perpetual duration. Still had the gold standard, even though the gold standard hadn't existed for nearly 100 years. We got all that cleaned up in the early 2000s. I want to spend a few minutes, a little bit longer than I have on these most recent ones, on education, right? And this is kind of a really important part of our Constitution. And so I put up here for comparison, first we'll talk about the 1901 language. Now, if you skip to the last sentence, you'll see, obviously, segregation was enshrined in our education article. Despite that, I would argue that our 1901 Section 256 was probably the most progressive education provision in any constitution as of that time, because it required the legislature to establish, maintain, and organize a liberal system of education throughout the state. That it had to be funded based on how many children were in each school district. And while it's segregated, it provided those, it at least in words provided that concept and that protection, irregardless of race. And so there is at least something to be said for that in the time period of 1901. And then you'll kind of see everything. So while far from perfect, a very progressive notion of education. And then what did we do? We amended it in 1956. Think about kind of historically, 1954 was the landmark case, Brown versus Board of Education, desegregation of schools. What does Alabama do? We amend our Constitution. And we do it for all the wrong reasons, right? We try to create an argument of, oh, we're not segregating based on race. We're segregating to avoid confusion and disorder and promote effective economical planning, right? We don't want to spend all this money on, busing or bringing people around. We've got all these reasons other than race to keep these schools separate. But worse than that, you go up here to the top and it kind of goes with this notion of, gone are provide for a system of liberal education. And here instead is, provide an education in a manner and extent consistent with available resources and willingness and ability of individual student. And by the way, nothing in this Constitution shall be construed as creating or recognizing a right to education at public expense. So this is a pretty huge step backwards, 50 years after that very kind of progressive 1901 language, and probably is a pretty good signal about why it is so dangerous to have a constitution that can be so easily amended kind of with the ebb and flow of what's happening in culture around it. These three articles, we're going to kind of skip at once: militia, oath of office, and miscellaneous. That militia language is pretty interesting, but not in the interest of an hour together on this meeting. And then Article 18 covers kind of how you amend the Constitution. Why is it so easy? So it's a 3/5 vote of the membership, and then it goes straight to the people. So the governor has no say in the amending of the Constitution. This doesn't go to her desk. She doesn't have a veto or executive amendment power. Once the legislature passes it, we send it directly to the Secretary of State, who places it on the next general election ballot, unless the legislature called for a special election to do it. And then similar provisions for local amendments. Again, one of the real outliers of this Constitution is how easy we make it to have an exception for just one county or one city. So efforts at revision, Albert Brewer, who became governor, he was lieutenant governor of the state of Alabama when Lurleen Wallace passed away while in office, and he finished the rest of that term. This was in the late 60s. Very progressive. This is when most other southern states were kind of ditching their 1900 era or post-Reconstruction era constitutions, Georgia, Tennessee, Mississippi, all did that in the 60s, early 70s. Albert Brewer formed a commission, said, hey, let's get on track, let's do it. Didn't make very much headway, and he was beaten by George Wallace when he attempted to get reelected in 1972. Chief Justice Howell Heflin, we talked about that Article 6 revision in the early 70s. That was kind of the first attempt at doing a whole article at once instead of an individual section by section amendment process. Interestingly enough, Bob James, in his first term of office, 78 to 82, put together a commission, had a new constitution. The legislature passed it, and it was set to be on the ballot for ratification in 1983. And the Supreme Court blocked it, said not so quick. Legislature, you don't have the authority to rewrite the Constitution all at once. You can only do it piecemeal. And so the people never had a chance to ratify the Constitution that came out of that James Revision Commission effort. Then in the mid-90s, Jack Venable and the suffrage article, we talked about that one in a little bit of detail. Then there was a Riley Commission in the early 2000s. It was structured largely around the tax section. We had an Amendment 1 effort to kind of rewrite all of the constitutional provisions regarding taxes. It failed very, very badly at the ballot in the early 2000s. And then Senator Del Marsh set up the Constitutional Revision Commission in 2011 that covered kind of this list of those ones that you saw that had those ratification dates in the 2000s. In November, those of you who are registered voters in Alabama, there's a huge chance at kind of a redo on a couple of key things in our Constitution. Amendment 4 would give the authority to my agency, the Legislative Services Agency, to recompile the Constitution in total, take out all racist language, take out any provisions that have been overturned by competent courts, that are no longer constitutional, consolidate things. When we get done with it, we'd bring it back to the legislature, who would have to pass it by a 3/5 vote in 2022, and then it would be on the ballot in 2022 to be ratified. Again, wouldn't fix every issue in the Constitution, but it would at least kind of hit reset, take out the most problematic parts, hit reset on kind of the structure. We'd start back over with a Constitution and no amendments instead of 950 amendments. And then hopefully be able to tackle some of those harder issues in a one-by-one basis after that. All right, so I've been doing a ton of talking. I have been watching the chat boxes. I haven't seen any questions come up yet, but I'd love to answer some questions in our last 5 or 6 minutes together. And so I don't know what's best. I'm gonna try to switch. Let me stop sharing and switch back to gallery view. If you got a question, you can kind of raise your hand on the thing or just scream it out or throw it in the chat box, and we'll do our best to answer whatever comes up. Come on, I know there's got to be something. I'll even take them from the advisors and board members. All right, so why is ours anecdotally considered worse than other states? Good question. And obviously this is gonna be a very high level answer to that question, right? I think the bulk of it is that very few other states, kind of with the history of secession during the Civil War, the vestiges of slavery, that whole kind of baggage that we have as a state, still have one as old as ours, right? I talked about a few minutes ago when we were talking about the Brewer Commission. Georgia, Mississippi, Tennessee, most other deep South states, sometime in the period between 1960 and 1980, kind of threw away their constitutions that looked like this and passed new state constitutions that look an awful lot like the federal Constitution. Shorter, much less specific, much less micromanagement, kind of ditched the segregation language, ditched the racist language, ditched the women can't vote language, right? And kind of hit reset on their constitutions, almost 80 years after the one we passed and still have is. So I think that's the main reason. I mean, I think if you looked at the Constitution that was in place at the turn of the 20th century in those other states that looked like us, they would have been equally bad. They would have been equally problematic. But at some point, 70 or 80 years later, they kind of started over, and we kind of missed that. We missed that boat. And has it been updated at all? Yeah, it's been updated. Okay, so is the language in the education article you showed us, the one ratified, still the same today? So that's actually a fascinating question. And the answer to it is it depends on who you ask. So my answer is yes, the 1956 language is still the operative language in the Constitution. There are some who would argue that it is not, that we're back to the 1901 Constitution. So why is that? I'll give you the really quick answer. In 1993, 1994 time period, educators and education groups sued the state of Alabama about how we fund public education. And in part, their argument was, hey, this 1956 language is clearly unconstitutional. The court should strike it. And then when you reinsert the 1901 language, it has all this, good language about a liberal-based education, and then the state's got to fund it. It was called the equity funding lawsuit. You've got to fund education more equitably. Trial court agreed with those education interests, bounced back and forth on appeals a few different times, and ultimately the Alabama Supreme Court threw it out without opinion on a ground mostly around, hey, you didn't have the right to sue to begin with. And so what that means is, there are some who would argue because of that trial court decision, then the 1901 language is back what's operative. However, the better argument, if you're sitting in the chair I'm sitting as kind of the code commissioner and keeper of the law, is that a trial court doesn't have that authority. It's got to go to the highest court of the state and have the highest court of the state throw it out before you actually take that language out of your Constitution. But there's kind of an argument about that. And it has not been updated at all as of this date. That is one of the things that would be updated if Amendment 4 in 2020 passes. What are the chances that Marcia's proposal that would allow ALI to work on the rewrite passes? I don't know the answer to that. I mean, I showed you kind of the trends. I mean, the trends are that we ratify most of what goes out to the people. That said, there was only one statewide amendment in March and it failed. And if you were following that, I'd like to argue that it's kind of a one-off. It was the provision that would do away with an elected state school board, but it failed. So I'm a little bit worried about, obviously, most well-heeled people, most people are happy with their state in life, kind of prefer the status quo, right? They don't like taking risk with changes. Status quo, that kind of a mindset might lead to people being inclined to vote against it, or at least that's kind of my concern. But I'm hopeful. I think it's got a better than 50% chance of passing. It should be a really high election turnout. There's a few other things people are paying attention to in the election cycle. Hopefully that means people get out and vote and they get educated and they vote yes on Amendment 4. Elaborate a little more on the reasons the Supreme Court ruled the way they did in State v. Manley. Sure. So Article 18 of the Constitution, which we talked about for just a minute, is kind of how the Constitution can be amended. And it sets forth two primary ways in which you can amend the Constitution. The first is to have a constitutional convention. And the Supreme Court said, hey, if you want to rewrite the whole Constitution, that's how the Constitution says you should do it. You should call a constitutional convention. You should elect people to go sit in a constitutional convention, and you rewrite the whole Constitution. The second method under Section 284 of the Constitution is where the legislature can propose amendments. And the court said, hey, amendment means something less than the whole, right? If it's an amendment, you're changing something inside the document. You're not rewriting the whole thing. And so they used kind of that, and again, really high level answer, but they used that as kind of the basis of their ruling was, amendment means something less than whole. There's this other provision about a convention rewriting the whole Constitution. Therefore, legislature's authority is limited to the amendment, and we don't think that involves the whole thing. That's kind of why Amendment 4 is structured the way it is, right? So Amendment 4 would create a limited window for a new method of amending the Constitution. And that new method would be that the legislature gets to rewrite the whole thing and propose it out. So Amendment 4 is kind of structured and written specifically to attack the grounds on which State v. Manley caused that to fail. I've got that it's right at 1, which I think is the case. I'll leave it up to y'all. I really enjoyed this time together. I'm sorry again that it was virtual. Maybe sometime over the next year we can get back together and do it in person. You know, I think you could spend days and days on the Constitution of 1901. So appreciate the opportunity to share this time with y'all, and thanks for having me.